Welcome to Brief Encounters, the DC Bar's podcast series. I'm Don Resnikoff. I'm with the DC Bar's antitrust and consumer law community. And today we have the great honor of having as our guest Angela Zhang, who is an outstanding expert on China's regulation of business, particularly regulation of tech business. I'm going to be brief in outlining her background and credentials because we have really a very short time today, and I want to talk really as little as possible. Angela is joining the USC Gould School of Law as a professor of law. In the past, she was a professor at the University of Hong Kong. She's the author of two recent books. Most recently, her book is High Wire: How China Regulates Big Tech and Governs Its Economy. And that's Oxford University Press just this year. Previously, not too long ago, she wrote a book called Chinese Antitrust Exceptionalism: How the Rise of China Challenges Global Regulation. And that too is Oxford University Press, and the year is 2021. And our main focus of discussion today is going to be on what is chapter 9 of most recent book. And that has to do with comparing policies of the United States, the European Union, and China. But I was going to suggest a slight digression before we start, in that in today's New York Times, and today is that we're making this recording is July 15th, there's an article about the Chinese plenum, which will review economic issues in China. And one commenter said that the great issue there is whether or not the plenum will shift the balance between the state and the market. And of course, this is a key topic in Angela's recent book. And I thought, Angela, I'd ask you just to comment briefly about the plenum, if you don't mind.
Well, Don, first of all, I would love to thank you for hosting me for this podcast. I am really grateful for your support all these years. I remember when my first book came out, you were the one who reviewed it. And then now my second book, you came to my book talk and also hosted this really nice podcast. So thank you so much. Now, going back to your question about the third plenum, and which is extremely timely, and I guess a lot of the investors, the lawyers, practitioners monitoring very closely the developments in China. I would personally hope that, the third plenum can shift the balance between the state and the market, because this is really important, right? I mean, particularly in my first book, Chinese Antitrust Exceptionalism, I delve into details of, why, in China, these firms never fight the agency's action, never resist the agency's demand, precisely because of this power imbalance between the state and businesses, where you see the state clearly has the upper hand, right? And then you see it even more clearly in my second book, High Wire. Would the third plenum change this dynamic? I doubt it. And I am not very optimistic that the third plenum would do any magic to the Chinese economy. And it's unlikely to shift the balance of power. Although I wish, sooner or later, Chinese policymakers will start to realize, giving more autonomy, more independence, and more support for the market, have more confidence in the market, will actually do Chinese economy better. Because now the Chinese economy is really at the rock bottom, and there's a big crisis of confidence among the consumers, among the investors, among corporations, and that's affecting everybody, including, lawyers practicing in China and those who work on Chinese deals overseas.
I see. So an element in your book is how the crackdown on some of these tech companies has not helped them to succeed. And so this is really a continuation of that same kind of problem, it sounds like.
Right. I do think that there is indeed legitimate reason for the Chinese government to go after these companies. And as I doubt very, actually go at length and explaining in the book, why the situation has gone out of hand in China. And in fact, China faces a greater demand to regulate big tech firms than their US and European counterparts. The problem, however, is how China went about doing it, right? I mean, its approach in regulating its big tech companies caused vast unintended consequences and generated a lot of backlash in the economy. And that's why, despite the fact that it was well intentioned and it was aimed at injecting more competition in the tech sector and in lower the barrier of entries, creating more innovation, but it creates so many counterproductive consequences because investors really panic. Investors were confused. They were very frustrated by the Chinese regulation, which they perceive as very arbitrary and very unpredictable. So as investors flee the Chinese consumer tech businesses, you actually have less entry because there's no more money flowing into the sector, right? I mean, so to the extent that, yes, it has weakened the big incumbents, firms like Alibaba and Tencent, but still, because of the lack of entry, it hardly changed the market competition, the competitive landscape, right? So in a way, it actually strengthened the market position of the existing incumbent. So this is precisely, an example where well-intentioned regulation can actually lead to worse outcome than where it started.
See, well, this leads me to say a few words about why I think people should read your book, buy your book and read it. And that is that your book does provide insights into China's regulatory scheme that goes well beyond the sort of cartoonish simplification we often get in the American press and American commentary and from American politicians. And I think that's pretty important. Another thing is that your book helps us to see that business regulation style in the United States is not a universal model. Different countries do regulation different ways. And that brings us to the topic that I originally wanted us to focus on today. And that has to do the subject matter of chapter 9 of your book, where you compare competition policies of the US, Europe, and China. And I'm going to take a moment just to take an excerpt from your book. You write at one point that while the United States follows a market-centric strategy, Europe advocates a rights-based philosophy, and China champions a state-centric model. The U.S. model reflects an unwavering confidence in market mechanisms and assigns a relatively limited role to government intervention. In contrast, Europe's approach is centered on protecting the rights and interests of users and citizens. Deviating from both of these models, China's strategy places the state as a central figure guiding and regulating the tech industry. And as you've mentioned, that you point out in a number of places that the goal of the China strategy is reducing income inequality. And then you also point out that progressive enforcers in the U.S. are moving away from traditional enforcement approaches, again, as you just mentioned, including the reliance on market definition and being more aggressive concerning merger enforcement. And you notice that there are similar trends in Europe and China. As you say, I think I am aware as a U.S. practitioner how the FTC's Khan and U.S. DOJ's Cantor are making social policy and political values more important in antitrust enforcement. So my main question for you is simply to ask that you discuss some of the main thoughts in your chapter 9, particularly compare and contrast the approaches of the EU, US, and China.
Right. I mean, this is a very good summary of this chapter. So the book actually has 11 chapters. And in chapter 9, I asked this question of, is China exceptional? Right. I mean, because the coverage about China's tech crackdown, when you see this kind of Western media coverage of China's tech crackdown between 2020 and 2022, it gave the impression that China is very exceptional in the way it went about regulating big tech firms. But in this chapter, I try to explain, look, I mean, actually, China is like a latecomer when it comes to regulate big tech because the US and the EU are actually ahead of China in regulating these companies, right? I mean, particularly in the US, you see this antitrust enforcement started to gain momentum across the political spectrum beginning 2016. And nowadays, there are many legal challenges brought by the DOJ and FTC against the leading big tech companies, although many of these actions were overruled by the court. And there's some bills were proposed, but none have gone very far, right? I mean, so things have moved relatively slowly in the United States. Europe, on the other hand, you see it's way more aggressive than its US counterpart, but particularly even more aggressive in recent years with the promulgation of the Digital Markets Act and Digital Services Act, specifically targeted at these big tech companies. But what I want to say is, look, I mean, in comparison, China's antitrust enforcement against its own big tech firms was actually extremely lax before late 2020. Right. So when you see there have already been a lot of actions in the EU and the United States before 2020, in China, there was none, almost none. We're literally talking about none. When people complain about, FTC approve Google's acquisition of DoubleClick or Facebook's acquisition of Instagram and WhatsApp, at least these deals were notified to the agency, right? But in the Chinese case, before late 2020, the merger authority did not wet any single deal in the tech sector, right? I mean, so you see the number one, number two, number three, number four firms merged together, and there was no merger control, right? I mean, we repeatedly see that in the rail handling business, in the e-commerce business, in the music industry, right? I mean, so you see, it was during this period, say between 2010 and 2020, you saw the exponential growth of the Chinese big tech sector. And it was kind of like, the Wild West, where you see two major tech firms, Alibaba and Tencent, becoming a duopoly. They are just gobbling up all the small portfolio companies. And in fact, each one of them own hundreds of portfolio companies and created their own ecosystem, while at the same time erected walled gardens to prevent the other camp to access their own ecosystem, right? So they were blocking each other with their own ecosystem, and they also block users from accessing their rivals' platform. These lead to this kind of abusive practices called choose one from two business practice, where say Alibaba will require merchants that sells on its platform to choose between its platform or its rival platform, precisely want to exclude them from competition, right? I mean, so, and over the years, the many complaints about these kind of abusive practices. For instance, JD.com has complained about this choose one from two exclusive practice dating back to 2015, but there was no antitrust action until late 2020, right? I mean, and it's not like the agency were not doing anything. It's just that the Chinese antitrust authority has vast discretion, and they have so many regulatory tools at the disposal, right? So they can cherry pick the more lenient regulatory tools like the anti-unfair competition law, which can subject the firms to a maximum fine of a couple million RMB, which means nothing for these big tech companies. Or they can just invite them for a cup of tea or conduct this kind of administrative interview with them and threaten them with antitrust law, but they never really seriously investigate these companies and these kind of abusive practices. And things didn't change until late 2020. If you may recall, at that time, in October 2020, Jack Ma made a very controversial speech, or you can say an infamous speech, at the financial summit in Shanghai that irked all the senior regulators there, because they thought that Jack Ma was challenging the fintech regulation, because Ant Group, which is the company that Jack Ma founded, and it was China's largest fintech company, was going unlisted, and regulators wanted to impose some harsh regulation on this firm. But in any event, that Ant Group's IPO ultimately was suspended after that infamous speech by Jack Ma. And then you saw the political wind shifted overnight. And then the top Chinese leadership decided to initiate a massive enforcement campaign against its own big tech companies. And from then on, that was a watershed moment, right? I mean, so from then on, we saw the balance is tilted from, supporting this platform now to decisively that we need to ring in this platform. And then, so starting in November 2020, we saw the first thing they did was the antitrust authority released guidelines to regulate internet platforms. And then a month later, on the Christmas Eve of 2020, they investigated Alibaba for the Choose from 2 business practice. Query why they didn't do that before, because there was 5 years lag time, and they did it, immediately in late 2020, and then finished the investigation within 4 months, right? I mean, they imposed a $2.8 billion fine on this company. It was an unprecedented fine, and that set the record in Chinese antitrust enforcement history, right? So you saw this very dramatic regulatory pendulum swing that you don't see in the United States or in Europe, right? Yeah. And then now, starting in early 2022, when the Chinese economy experienced very deep financial trouble, and there's a massive sale of Chinese stocks, then the Chinese regulators and the top policymakers then announced a regulatory easing, sending a very strong signal to the market they're going to ease regulation. And so everything returned back to the routine and normal again, right? So if you talk to any of the Chinese antitrust lawyers these days, they would say it's extremely quiet, right? I mean, it's quiet for many reasons, right? I mean, the Chinese economy is not doing well. There's very few deals, but it's also because agencies were were very quiet. You hardly heard any active actions since early 2022, right? So the last couple of years, it's become extremely quiet. So we went back to another extreme, from very strict and now to very lax, right? I mean, when you see in the US and EU now, antitrust authority is now investigating OpenAI, investigating Microsoft, NVIDIA, these AI firms for potential antitrust violations, right? I mean, in China, you don't hear anything, right? I mean, this is not the time agency will take aggressive action into the tech sector, because now the main priority is how we can stimulate the economy, how we can win back investor confidence, and how we can revive the slowing Chinese economy. Go back to the third plan of question you asked me at the beginning.
Right. And now it strikes me that in terms of compare and contrast, that your pendulum swing point for China is quite a contrast to the United States, where the pendulum may be swinging a little bit with the new FTC and the antitrust leadership, but because of the courts, it's a very slow swing. And
yes,
when I go to conferences where people are discussing that pendulum swing, people who are representing business interests really emphasize that the courts should be keeping stability in place, protecting the due process rights of the companies, and holding back the pendulum swing. So that's quite a difference. And I guess from what you've said, it's in my observation too, Europe is somewhere in the middle, that it's willing to, maybe depart a little bit from the rigors of due process and telling the defendant exactly what they did wrong to what is best for the consumer, and working on that sort of basis.
Yeah, I definitely agree with that observation. And I think that the major reason why the Chinese regulation fell is not because they try to regulate. It's because the way they went about regulating, because of the absence of checks and balance, the lack of due process, that really created a crisis of confidence among the investors and the entrepreneurs, right? I mean, so ultimately, it was their lack of confidence in the rule of law system in China, right? It's not that China needs to regulate this company. It's that they have no faith in how China regulates. Whereas in the US, yes, I know I share a sympathy with a lot of the progressive policymakers and academics about, the need to regulate these big tech companies. And I understand where the frustration comes from, because the courts, were not very supportive of many of their actions. But I actually think this is a blessing in disguise, to be frank. I mean, this is precisely, in a way, it's the beauty of the rule of law system, right? I mean, it's not the most efficient system. If you're talking about the most efficient, look at what China did, right? I mean, they can, overnight decided that we want to rein in big tech companies. And then they can promote all these laws within months. They can nail down these firms with record fines within months. But look, what are the outcome? Well, the consequences are not good, right? I mean, precisely in the US and in the EU, there is more robust checks and balance within the legal institution. And that's a good thing, right? I mean, despite, the fact that, sometimes you don't want your pendulum to swing too quickly because it may actually generate more backlash and lead to a lot of unintended consequences.
But hopefully there's a happy medium where you have just the right amount of pendulum swing to move things forward. And in fact, the question would be, do you feel, for example, the European Union is better, for lack of another word, is the European Union better in terms of balancing rigors of due process against consumer needs?
I used to practice a little bit in Brussels, and I also taught at a British law school called King's College London. So I had a little bit experience with the EU system. But at that time, Britain was still part of the EU system. What I thought was quite frustrating at that time was the fact that I feel that the EU court, the General Court and the Court of Justice seems to be way too deferential to the European Commission. And so I was very curious about why they're so deferential. And then I actually did extensive research about the court and discovered a series of problems with the EU judicial system. I wrote a paper called The Faceless Court. Basically, it's an article that was inspired by my own personal observation as a practitioner and a scholar on EU law, that why I find that in Europe, courts are so deferential to the agency that they don't really challenge the agency action that much. And that drove me to really study the court. And the article really exposed a serious problem about the EU institutions. But suffice to say, let's bear it in mind. EU is a transnational organization, right? I mean, and there's very close collaboration among different EU institutions, and because they are all part of the same system, right? I mean, so you can't expect the same level of checks and balance as you see in the US system, where courts and judges are entirely independent. A lot of them serve for life, and then they're not, unlike the EU judges, which they are heavily influenced by the French legal tradition. There's less deference for the agency action, and judges in the US are more prepared to challenge agency action. So there's many ways, many reasons, but both institutional reasons, cultural reasons, even language reasons, why we see in the EU agencies is way more aggressive, actually take a more central role in regulating the big tech sector. Whereas in the US, the courts play a very important role. I mean, it's a very important actor in this area.
Yeah, that makes a lot of sense. And that the courts in the US really are a big source of the rule of law idea of due process and so forth. But now I want to ask you sort of, I guess, an unanswerable question is that your book is sort of a teaching tool that people reading it, if they were officials in government, would see, okay, I see how you get it right. You set up the administrative agency so that they have some authority. They operate under a rule of law. So what they do is predictable and can be understood by the companies that they're regulating. And so it's a puzzle to me. If the goal of Chinese leadership is to help these companies be successful, and within reasonable bounds, restrictions, why don't they adopt some of the sort of the insights of your book? What holds them back?
Well, I mean, I think what we observe with the Chinese tech regulatory outcome, it's actually not unique in the way China regulates in general. And in fact, the book was quite ambitious in trying to apply the same regulatory model to analyze other areas, how China regulates its economy, like how China regulates property sector, how China regulates COVID-19 control, how China manage energy crisis, how China manage the one-child policy. And again, you see the same pattern of regulatory governance. And the reason why you see this kind of dramatic regulatory pendulum swing actually goes back to China's unique political regulatory system, which is the first distinct feature I identify, which is I call hierarchy, right? Because the regulatory system is characterized by players situated in different tiers of the Chinese society. At the apex, you have the top leadership, and then you have the regulators in charge of the day-to-day implementation of the TOPS policy. And then you have the firms, which rarely resist the agency action. And at the bottom are the people, because their voices tend to be muted or censored, right? I mean, and so they're not a very active player in the system. Now, in this kind of unique system, the most important player is the top policymakers, because they sit at the apex of the political hierarchy and they set the agenda for the economy. But they lack the expertise and the time to manage everything. And that's why they have delegated to a lot of responsibility to the agencies themselves. Now, from the agency standpoint, this kind of very tight hierarchical system tend to lead to a paradoxical phenomenon. The agencies either do very little or do too much, right? I mean, this is precisely what we already talked about at the beginning of the show, right? I mean, in China, at the beginning, when they regulated the tech sector, there was hardly any regulation. They did very, very little. And then later on, when they received very clear signal from the authority that, okay, we need to rein in the tech sector, then you see agency overreach. They tend to do too much in order to demonstrate the loyalty to the top, right? I mean, so you see this paradoxical phenomenon, too little and too much, and very dramatic. It's precisely because agencies in the Chinese hierarchical system, they're not accountable to the people, right? Because this is not a democratic system. This is an authoritarian system. Agencies are held accountable to the top, right? So when the top was saying that we need to be nurturing the system, we need to be tolerant, we need to be cautious with regulating our platform economy because this is supposed to boost employment, supposed to help upgrade Chinese industry, right? And so agencies did not dare to act, right? So that's why they tolerated all these reckless expansions in the tech sector for the first decade. They tolerated a lot of abusive practices until things become really out of hand. Then they decided, okay, we need to rein in the tech sector because now the top has told us to do that.
Okay, well, that's a very interesting answer. And I think we're going to have to stop here simply because we're more or less out of time. But I would say that I think this discussion should illustrate to people listening why they should go out and get your book and find out more detail on what you've just explained, which is, I think, interesting and important. And so with that, I'm going to say thank you very much for your time.
Thank you so much, Don.